And we continue our coverage of that case that has been brought by South Africa at the International Court of Justice in The Hague, which will hear Israel's defense in position after the South Africa accused it of a genocide in Israel, in the Israel-Hamas war. Yesterday, South Africa argued that Israel's conduct is in contravention of parts of the Genocide Convention. Senior lecturer at the Department of Political Science at the University of Pretoria, Dr. Sithembile Mbete, joins us now to discuss this matter with us, as she's joining us now via Teams. Dr. Mbete, good morning. Thank you so much for making time for us. Let's start off here. The reaction from South Africans in general to the presentation that was made. Of course, there are some mixed views, but the president yesterday, while addressing ANC members, speaking about pride and the sense of pride that he felt. And I saw that even on social media that there were some people arguing the same. Even with the listeners on SAFM, there were some that were saying that they have a sense of pride. What do you think this moment means for South Africa in general?
Good morning, Aldrin, and to all of your viewers. Thanks so much for having me. I think that this moment, and certainly the public hearings yesterday, were a moment of immense national pride for South Africa to see our legal excellence on display in front of the world across generations, from Professor John Dugard, who is 87 and was one of the first and most prominent legal minds to conceptualize and to write about the idea of apartheid as a crime against humanity, and has long been a human rights lawyer in South Africa. He's got a career stretching back nearly 60 years. And then to the younger generation of lawyers, Advocate Ngai Toby, Advocate Hassin, and then the juniors that work with them, who really laid out an incredibly detailed and the first such comprehensive case of the crimes that have been undertaken in Gaza since the 7th of October 2023, but really in the whole of Palestine, both Gaza and the West Bank, the occupied territories, since 1948 for the last 75, 76 years. And I think that that kind of setting out of such a world historical case is something that South Africans can be immensely proud of. And I think that we saw evidence of that on social media yesterday. I think also what you've had is, and there was a profoundly poignant moment when former Deputy Chief Justice Dikgang Moseneke was sworn in as one of the guest judges to the ICJ, given his history as a fighter against apartheid. Yeah,
actually, touching on that as well. Some people were saying, just looking at former Deputy Chief Justice Dikgang Moseneke being sworn in, thinking of him as an anti-apartheid activist, a former member of the PAC, and he writes quite passionately about land. And at the core also of the debate and the war between Israel and Palestine is actually a question around land and occupation and disposition.
Yes, certainly a major part of this, and indeed the South African case of genocide is about the elimination of of a population in part or as a whole in a particular territory, and in this case in Gaza. So there's a lot around land dispossession and around displacement and forcible removal of people from their historical lands that is at play in this case. I think something that was also really touching about Dikgang Moseneke being our guest judge is that let's remember that he was imprisoned on Robben Island as a child. He was 14 or 15 years old when he was imprisoned, one of the youngest prisoners ever on the island. And given that so much of South Africa's case on genocide hinges on the treatment of children and the non-discrimination between combatants and non-combatants, and the targeting not just of people suspected to be Hamas combatants, but of women and children, including babies.
Yeah, well, you have all of that symbolism that is on display, unfortunately, or fortunately perhaps even. The focus is going to be on whether South Africa was able to prove its case, at least to get the court to hand down an order for the provisional the provisional measures that they want to see being taken, and also to ensure that after the order is handed down within a week, I think the Ambassador Madonsela said, Israel should then also report back to the ICJ. Do you think that South Africa has been able to meet that threshold, also on that argument around a genocidal intent?
So I think let's remember that for the indication of the preliminary measures, South Africa just needs to prove that there is a plausible case that the actions that we have seen that Israel has undertaken in Gaza could amount to genocide. They don't need to prove the substantive case in order for the plausible measures to be implemented. And certainly we heard from Council yesterday a detailed accounting of the ICJ's own jurisprudence, its own precedent on the issue of preliminary measures, most recently in the case of the Gambia versus Myanmar, where the ICJ has stated itself that it does not need to judge on the merits of the case in order to be able to hand down the preliminary measures. And so I think that in terms of the ICJ's own law and its own case law, South Africa does have a strong case of winning those preliminary measures. Of course, we will hear what comes from Israel today and whether they manage to convince the judges of the court that there is no plausible case to be made that the actions and the military intervention that it has undertaken in Gaza amount to genocide. I think that on the genocidal intent, something that was done yesterday in the hearing that wasn't done as much in the application is the linking of the statements of Israeli officials in the government, in parliament, and then also in civil society generally, to the actions of soldiers, and using the TikToks, the social media of the soldiers themselves to have them quoting what had been said previously by the Prime Minister, by the Defense Minister, to justify the actions that they were undertaking. And so that link between the statements of officials and the actions of soldiers is really critical in being able to make the case for genocidal intent.
Yeah. What about the complexity of this matter? It has been before the United Nations since, I think, 1946, 1948, and still no clear solution has been found. And there's been also the proposal for a two-state solution, and we know where Hamas was when it comes to that particular part. Do you think that the court will be able to deal with this matter, considering all of its complexities as well, within the next week or so?
Well, I think that the South African legal team is very aware of this matter of complexity. Indeed, in his opening statement, Ambassador Madonsela spoke about the decades-long impunity for widespread and systematic human rights violations that had emboldened Israel. And certainly Israel has been in violation of both orders of the ICJ. There was one that was quoted yesterday from 2004, but also of multiple UN Security Council resolutions and UN General Assembly resolutions. And so Israel has been able to act in complete violation of international law and of the mechanisms that have been put together to maintain international peace and security for decades. And so whether or not it will abide by this particular ruling, if and when it comes, is a matter to be seen. I do think that the importance of such a ruling from the ICJ will be firstly on putting pressure on the government of Israel internally. We know that there is actually a great deal of dissent within Israel and many people that disagree with the actions of the government. And this would embolden those forces of dissent within Israel. But secondly, it's going to put pressure on those countries that have supported Israel thus far, including the United States, because any kind of ruling from the ICJ that says that there is a plausible case to be made that Israel is undertaking genocide in Gaza will place the Americans and others in a very awkward position, particularly in relation to the sale of arms and the providing of military support. And so I think that the complexity of this is well understood, but that also is one of the things that makes what happened yesterday so significant, because it was almost a forcing or bringing to the head of a decades-long dispute. And then just the last thing on the two-state solution, one of the critical things is that the set and occupation activity that Israel has been undertaking, particularly in the last 15 years of building settlements in Palestinian territory, is making it increasingly impossible that a two-stage solution can be reached, because the boundaries of Israel have so far extended beyond the borders that were expected to be the borders of any kind of two-state solution, that going back to the drawing board is going to be necessary to work out how Palestinians and Israelis can live in peace at whatever point.
Yeah. Another part of this case, of course, is that before the ICJ, it is state to state. It's a dispute that South Africa has lodged against Israel. So it's state to state. And as South Africa points, or rather as Israel points out, what about Hamas? And we heard in the opening remarks, of course, that there were the emphasis around what Hamas did and the condemnation of what Hamas did on the 7th of October. However, when the order is handed down, the order, and South Africa is successful, it will be an order against Israel. What about Hamas? Hamas, which is not a state, but it is Hamas actually that launched that attack on the 7th of October.
Well, the preliminary measures that have been requested by South Africa fall within the bounds of what the ICJ can order on. And all of the ICJ's power is in regard to states. And so this is a dispute among states, two states, and one that has lodged a dispute with another state. And so within the ICJ's power is to make some kind of ruling on the behavior of those states. Remember that in South Africa's preliminary measures, there's also an obligation on its part so I think it's the third or fourth of the preliminary measures that have been requested, is the statement that South Africa, as well as Israel, must ensure the prevention of genocidal acts within their reasonable powers. And so, that's what's possible within the statute of the ICJ. The issue around Hamas can be dealt with in other ways. Certainly the ICC remains a platform that states, parties or others can use to prosecute the crimes of Hamas and individual Hamas leaders, because the ICC deals with individuals, not with states. However, a point that was made repeatedly by South Africa's legal team yesterday was that not all crimes of violence, not all crimes in a war amount to genocide. And there's a very specific reason that this case is being brought to the ICJ in terms of the Genocide Convention. So have there been war crimes perpetrated on both sides? Yes. Have there been crimes of against humanity perpetrated on both sides? Yes. However, do all of those crimes amount to genocide is the question that the ICJ is going to have to deal with in this case. And I think the argument that was made quite convincingly by the South African team yesterday is that Hamas's crimes do not amount to a genocide in terms of the definition of genocide given in the Genocide Convention.
And again, on the 7th of October, on the 6th of October, at least, there was nothing that was happening between the two states. But we know that there's a history of a conflict between Palestine as well as Israel. There is that particular history. But on the 6th of October, there was absolutely nothing. On the 7th of October, Hamas then launches that particular attack. The question for me is, what conversation should be happening with Hamas as well? Because you need to bring Hamas in, that if Israel, for instance, was to stop its attack, what assurance could there be that Hamas won't attack Israel again and Israel retaliating?
Well, the first thing I want to correct is that there was absolutely nothing happening on the 6th of October. There was an occupation. You had people in Gaza living with restrictions on movement, not being able out, people from the West Bank not being able to get into Gaza, restrictions on medical supplies, on food. That has been the ongoing state of life in Gaza for 15, 16 years. So to say that there was nothing going on the 6th, and then all of a sudden,
in terms of conflict, there was no. What I'm saying is that there was no conflict. At least on the 6th of October. But on the 7th
of... There was conflict, there was no active war.
Yes.
There was conflict, but there was no active war. And I think that's an important distinction to make. However, to answer your question, the cessation or the suspension of a military operation then creates the conditions for some kind of peace negotiations to be undertaken. You can't start negotiating around peace until there is some pause in hostilities. I mean, that's just standard practice in peacemaking and peace building. And so the first thing that needs to happen is the end of a military operation. And the greatest, inflictor of military harm currently in Gaza is the Israeli state. And so you need to have some pause in that to then be able to create the conditions for negotiations and to get then Hamas to stand down. This is not some unique thing to Israel. That is to Israel and Gaza, or Israel and Palestine. That is the case in all conditions of war. And so the first thing that needs to happen is for the military hostilities to be paused, some kind of ceasefire, some kind of suspension, to then be able to have the negotiations that need to happen to end the conflict altogether.
Thank you so much for your time. That is Dr. Sithembile Mbete, and as you indicated there, also need to be very careful with the wording. There was conflict, but not an ongoing war.